president of the chapter. And before I turn this over to our speaker, I want to announce a couple upcoming events. On February 25th, so next week, we have another event. Steve Simpson, who is Director of Legal Studies for the Ayn Rand Institute, will be speaking. His topic is The First Amendment Isn't Enough. And then on March 30th, we have Tara Smith lined up. She's a professor of philosophy at UT. She's discussing her new book about the proper role of judges and the legal system, and I think it's called Can the Courts Get It Right? So look for those announcements. If you're, I think she means the appellate court. We put them out on Facebook. If anyone likes to look at Twitter, we tweet the events. If you're on National's mailing list.
Just as well as tweeting as we speak, so you know it's up there.
National sends out our invites, but I would like to mention to people that if there's others in Austin who would like to know about our events but aren't necessarily dues-paying members, they're welcome to come. And if you want to get us their email addresses or tell them to follow us on Twitter or Facebook, we'd love to grow the audience and add people who faces we don't normally see. Sometimes our topics are interesting to folks who may not be generally interested in what we do. So any ideas are appreciated. And with that, I'm going to turn this over to Arif Panju, who is on our steering committee, and he aligned up today's speaker.
Thanks, Art. There are competing visions about the role that judges should play in policing the legislative branch and the executive branch. For some, judicial deference to majority rule is something that they favor. For others, judicial engagement, less deference to a Leviathan government, more protections for individual liberty are what they advocate for. These spirited debates have taken place since our founding. They're going to continue as we select our next justices over the next several years.
Months.
And months. And that's what today's talk is about. And our speaker today is Professor Josh Blackman. Professor Blackman is a professor of constitutional law at South Texas College of Law. He also specializes in U.S. Supreme Court. He's written a couple of books I should mention. He's the author of Unprecedented, The Constitutional Challenge to Obamacare, which was published in 2013. And this year, Cambridge University Press will be publishing his current book, unless it's already come out.
Have to finish writing it first.
Okay.
A new chapter is added this week.
But that book is called Unraveled, Obamacare, Religious Liberty, and Executive Power. Professor Blackman is also an adjunct scholar at the Cato Institute. He's written dozens of law review articles. His writings appear nationwide in publications and in newspapers. And today he'll be talking about the next justices. Please join me in welcoming Professor Blackman.
Well, when Arif asked me to come here to talk about picking the next Supreme Court justice, there was a different theme for my talk. It was all very speculative and hypothetical, but the events of the last week have crystallized how momentous this decision is. So before we begin, I want to show you a picture which is not even 2 hours old. I put the slide in the cab right over. This was a scene this morning from the United States Supreme Court as Justice Scalia's casket was brought into the court. And before we begin, I'd like to take a moment of silence and send our prayers to the Scalia family and the Supreme Court family. Thank you. I was watching it this morning, not even an hour ago, across the river at the Hyatt, and I was shedding tears. 98 of Justice Scalia's law clerks flanked the steps leading to the top of the U.S. Supreme Court. His honorary pallbearers, people like Paul Clement and Jeff Sutton and others, were walking behind the casket. Justice Scalia's coffin, or casket to my IJ friends, right? This casket is sitting on top of the same, I can't say the word, but the same holding that held Abraham Lincoln's casket after he was assassinated. I don't know the word, I can't say it. It is a word, it's a weird word. But the thing that held Abraham Lincoln's casket is now holding Scalia's casket. The justices are standing in precedential order, as they always do. The Chief Justice, now the most senior Associate Justice, is Justice Anthony Kennedy. Justice Clarence Thomas, Justice Ruth Bader Ginsburg, Justice Stephen Breyer, Justice Samuel Alito, Justice Sonia Sotomayor, and Justice Elena Kagan. I only said 8 names. We have a court now with 8 justices. And the loss of Justice Scalia is so hard to quantify. I began class the other day with a remembrance, trying to explain to a 1L, a first-year law student, what Justice Scalia meant is impossible because they don't remember what the world was like before Nino Scalia came to Washington, D.C. Men and women in this room maybe have a sense. So I tried to explain to my students at least 3 major contributions, and they're far more than 3, but at least 3 major contributions by which we can remember not this Scalia, but this Scalia. What are you talking about, Scalia, right? This is a Scalia that we have to remember. So the first major contribution of Antonin Scalia is textualism. The idea that we look to the text of a statute to know what it means. And this, of course we look to the text. Where else would we look? There was a time in the Supreme Court in the 1970s where you would read a decision that says, because the legislative history is not clear, we turn to the text. This is how the Supreme Court used to understand statutes. Nino Scalia slayed that dragon, almost single-handedly. When lawyers came to the Supreme Court citing legislative history, he's like, give me the text. Any opinion he wrote, he refused to cite legislative history. Indeed, if he joined a majority opinion that cited legislative history, he would dissent from it, just that one sentence. So after a while, you know what? His colleagues stopped citing it. It worked. It worked. Another major contribution of Nino Scalia is originalism. Justice Scalia did not make up the notion that we should interpret the Constitution as it was originally understood. He didn't make that up, but he brought it to the forefront. He drilled it into the hearts and minds of lawyers across the country. So much so that in 2008, when the court decided the case of District of Columbia v. Heller, the Second Amendment decision, we had to understand, what does the Second Amendment mean? Both the majority and the dissenting opinion were all originalist. Scalia forced John Paul Stevens into a terrain he never thought he'd have to fight in. What did James Madison think about the Second Amendment? In my humble opinion, and I'm sure friends would agree, Scalia got it right and Stevens got it wrong. But the fact of the matter is, they were both originalists then. And Justice Elena Kagan, who quickly became Scalia's favorite hunting partner in the court against all odds, said a couple years ago, quote, "We are all originalists now." And that is a debt we owe to Justice Scalia. And it's a debt we can only hope to pay forward. The third major contribution that I told my students about from Justice Scalia was the idea that law is not politics. Before Nino came to the bench, there was a justice by the name of William Brennan. Funny, I gave this talk in New Jersey a couple of days ago. The dean of the Rutgers Law School got mad at me, but I'm a Texas here, so we're going after Brennan here. Justice Brennan would say, what's the law? He held up 5 fingers. Whatever you can get 5 votes for, that's the law. This is what law students were taught. The law is a living tree with roots and branches and goes wherever you want to be. Scalia said no. Scalia said the rule of law is the law of rules. It's one of his most famous articles. And he holds up a couple examples of this principle. One of these principles was a case from right here in Texas called Texas against Johnson. This was the flag burning case where at the 1984 Republican National Convention in Dallas, some scruffy hippie was burning an American flag in an act of protest. He was arrested and charged under a Texas statute for desecration of the flag. His case went to the Supreme Court. Now, if this was the court of popular opinion, Scalia would have crucified the guy. But Justice Scalia was sitting as a judge with a robe, and he voted to invalidate the conviction of the flag burner. He would always hold this up as an example, saying, listen, you know you're doing it right as a judge when you vote for the guy that you want to throw in jail. You know you're doing it right. In fact, there's a funny story, which is almost certainly false, but I've heard it from a few people, is that the day after Texas v. Johnson was decided, the Washington Post published on the front page, court upholds flag burning. And Justice Scalia's wife, Maureen, who's very conservative, even more conservative than he, looked at him like, what's this? And then she started humming the national anthem. And apparently Scalia said, I don't need this shit, I'm going to work. And he left for the court. But that was Nino in a heartbeat, right? Even when he disagreed with the outcome, he voted where he thought the law took him. The First Amendment guarantees the right of free expression. Another example, Justice Scalia was one of the best friends of criminal defendants. Huh? The Sixth Amendment guarantees the right of confrontation. It says you have the right to confront your accuser. For years, the Supreme Court ignored that provision. They said as long as evidence is reliable, it can be admitted as hearsay. You don't need confrontation. Scalia said, no, 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 no. That is not what the Confrontation Clause means. And he fought, and he fought, and he fought. And in 2006, the case of Crawford against Washington, the court said the Sixth Amendment means what it says and says what it means. That you have the right to confront your accuser in open court. That this is a fundamental safeguard of our Anglo-American system of civil liberties. And you want to know what? It was an originalist opinion, checking with the trials for Walter Raleigh and how our framers understood confrontation. Scalia's vote helped a lot of bad guys. It helped a lot of defendants. People I'm sure Scalia would just as well have locked away and signed away the key. For Justice Scalia, principles mattered. Now, it's often said that, in this case, Justice Scalia was in principle. In that case, he didn't stick to his guns, right? Sure. But the only reason why you can say that Justice Scalia was not principled was because he had principles. The same cannot be said for many judges. We owe him a great and momentous debt that I only hope that groups like the Federalist Society and law students and attorneys and friends can help to perpetuate, that we remember as good, we can remember as bad too. We screwed up on some stuff, race among others, but we can remember the good and the bad, and hopefully always keep his memory in our heart. And I'll be happy to take questions about Justice Scalia afterwards, but I'd like now to segue into the topic that they invited me to speak about, which is selecting the next justice. Now, I've been giving this talk now for almost a year, and this talk has changed significantly in the last 6 days. In 2017, that man, John Roberts, will inaugurate a man, or maybe a woman, or who knows what, into the office of the presidency. Now, we're nonconformists here, right? That person may have to make an important decision about appointing an ex-justice. Or the person in the White House now may have to make that decision of who to appoint to the Supreme Court. Now, let's address the Constitution here for a moment. When Justice Scalia died last Saturday, no one had a game plan. Usually in Washington, things are planned out months and years in advance. There's a script you have to read. But on Saturday, everyone panicked. Everyone panicked. Within hours, the Senate Majority Leader said we will not have a hearing. 2 hours later, the president, without even a tie on, eulogized Justice Scalia and said, look, we're going to pick his replacement real soon. Classy. No one knew what to do. No one knew what to do. So let's talk about the constitutional text for a minute. The Constitution says the president shall nominate. Shall means must. So the president has an obligation to fill any vacancy on the Supreme Court, right? He has to. That's actually one of the few things Obama has to do. He'll actually do. This he'll actually do. The Senate's role is what's called advice and consent. Advice and consent. What does that mean? Whatever the Senate wants it to mean. The Senate is not required to hold a hearing, not required to do anything. If they see the seat best left vacant, they can leave it empty. How do we know this? Well, Nino told us. In the 2014 decision of National Labor Relations Board versus Noel Canning, this was a case involving President Obama's recent appointments to the NLRB. And President Obama said, I need to make these recess appointments. Why? Because if the National Labor Relations Board drops below 3 members, they lose their quorum. And then this important governmental agency goes dark, right? They can't make labor rules, do everything else that they do. And what did the Supreme Court do? They said 9-0 no. A gridlocked vacancy is not a reason for the president to act unconstitutionally. And Justice Scalia's dissent, which reading it now is so chilling, indeed telling us what's happened. Scalia said the mere fact that there's gridlock in Washington does not mean the president gets to do something he usually can't do. The Senate has a constitutional prerogative. They can deem the seat best left empty, and that's their decision. That's their decision. That's their entire prerogative. So I'll understand the rest of this talk is whether or not the Senate holds a hearing or votes for President Obama's nominees is purely and entirely a political question. There is no constitutional issue here. None. Zero. Zilch. If the Senate wants to not have a vote and that hurts them the next election, well, then that's their call. But that's entirely within their prerogative. Nothing can be done otherwise. So beyond Justice Scalia, though, the next president will have a number of important decisions to make. Justice Ruth Bader Ginsburg, she called Nino her best buddy. If you want to cry and see how a liberal and conservative should be friends, go read her statement. It's really touching. RBG will be 83 in 2017. Justice Anthony Kennedy, the locus of our universe, he will be 81. Right? We don't have a geocentric universe. We don't have a heliocentric universe. We have a Kennedy-centric universe, right? He'll be 81. Stephen Breyer will be 78. So on 2017, we may have a president who can have up to 4 vacancies in the Supreme Court. And not since Richard Nixon has a president had such a potential to shape the court. But the thing about Richard Nixon is that he didn't take his vacancies very seriously. He appointed to the Chief Justice Warren Burger, who proved to be pretty inept. He appointed Harry Blackmun to the Supreme Court, no relation. Harry Blackmun wrote the decision Roe v. Wade and became a staunch opponent of everything that was conservative. William Rehnquist, who later became the chief, was perhaps Nixon's only pick that made any sense. And Lewis Powell was selected because he wanted a Southerner. Really, so he picked a Virginia moderate. Republicans don't have a very good shot at picking judges. In fact, Sandra Day O'Connor, who apparently is still talking to the press, she said, "Oh, get on with it, confirm the next nominee." Well, Sandra O'Connor should know something about a Supreme Court nomination for just getting it over with quickly. She was selected by Ronald Reagan. Reagan also selected Nino Scalia. Here he is in his much younger and thinner fame. And Reagan also selected this man, Anthony Michael Kennedy. And the selection of Kennedy, which I'll talk about more later, is so salient. The reason why we have Anthony Kennedy is because Joe Biden and the Democrats stopped a man named Robert Bork from going to the Supreme Court by a vote of 58 to 42, 2-vote short of cloture. And even then, we have the modern day Supreme Court, where John Roberts and Sam Alito were picked by Republican president. And as my first book, and unfortunately my second book chronicle, with respect to Obamacare, Roberts did what he did. So how is it, right, that of the last 7 presidents, only 2 Democrats were able to make appointments? Only 2. Carter had none, thankfully. How is it possible that 5 Republican presidents over the last 4 decades would not yield a supermajority of conservatives in the Supreme Court, right? These are the 16 justices. I just went through their names. People like Harry Blackmun, David Souter, right? How did this happen, right? How can it be that 4 justices appointed by Democratic presidents and 12 justices appointed by Republican presidents? How can it be that we are where we are, where we now stand at the precipice of having a super majority in the next 4 years of Democrat-appointed justices? If President Clinton wins, she may get 5 nominees to the Supreme Court. Right? You'll have Roberts, Thomas, and Alito hanging out by themselves. Well, the way this happened is that for the most part, the Democrat nominees have voted in a consistently liberal fashion. People might call Stephen Breyer a moderate, and indeed he is. But I'll humbly submit that the difference between Stephen Breyer and Ruth Ginsburg is awfully small. There may be a couple cases every year where Ginsburg and Breyer vote differently, but they're together for the most part. So I want you to watch the transition, right? So we have here the red and blue. Pay attention for it. Ready? Boom. So what happened? A number. Whoa, one more time. There it is. A number of Republican-appointed jurists became either quite liberal. In the middle, you have Souter, you have a Berger, you have Blackmun. Or we're kind of in the middle. You have Lewis Powell, you have Sandra O'Connor, and you have Anthony Kennedy. You notice none of those jump to the right. Democrat judges don't jump to the right. In fact, the last one who probably did was Robert Jackson and Frankfurter. So maybe Jackson and Frankfurter. I mean, we're talking, you have to go back to the New Deal to see when they jumped to the right. Why did they jump to the left? We'll talk about it more later. But the fact of the matter is, Republicans have much more to worry about. Okay? Republicans have much more to worry about than Democrats with judicial elections. So to bring it back to the present moment, when Barack Obama says, I will appoint a moderate as opposed to a liberal, I'm like, what difference does it make? To quote Miss Clinton, right? What difference does it make? What difference does it? It doesn't make a difference. It makes no difference. Maybe in 1 or 2 cases at the margin, Sri Srinivasan will vote differently than Pam Carlin. But, it's at the margin. So a few months ago, before any of this started, September of 2015, Professor Randy Barnett at Georgetown and I, we wrote a piece in the Weekly Standard called The Next Justice. And I actually feel dirty now because Scalia's cut out. Oh, man, I got to take this slide out. All right, well, got to get some real-time edits. And in this paper, we offer 5 lessons for a Republican presidency of how to pick the next justice. And the first lesson to learn, and this is a lesson that's extremely instructive for what's happening in Washington today. The first lesson is that bruising confirmation battles are worth the political capital for a lifetime appointment. The amount of political short-term hell you have to pay for a Supreme Court justice is worth every vote that you may lose. With respect, if the Republicans lose 1 Senate seat, a moderate, because they held the line on President Obama's nominees, okay. We won't remember in 30 years a moderate senator who lost a couple votes because we now have an Obama nominee in the Supreme Court. We won't remember, right? If I go to the average person in the street and I ask them, who is Robert Bork, they'll have no idea. But if I ask them who's Anthony Kennedy, oh, that they'll know, right? They'll know Kennedy. They won't know Bork. Actually, they won't know Kennedy. More Americans know who Judge Judy is and who a Supreme Court justice is, but you get my drift. As the average law student, they'll know who Kennedy is. They won't know who Bork is. So what happened to Mr. Bork? President Reagan nominated him. Oh, here's actually a funny story to tie in Scalia. Reagan knew he wanted to appoint 2 men to the court. So first he did a woman with O'Connor, then he had Scalia and Bork. The only question was who would be first and who would be second. Scalia got the nod first. So then Bork said, okay, I'll be up next. Had Scalia been nominated second and Bork first, Bork very likely would have gotten through in 86, and Scalia would have gotten through in 88. We would probably have both on the court. The fact that they flipped the order is cosmic. Another rumor is that apparently they banned smoking in the Senate the year of Bork's confirmation hearing. He was a nicotine addict. Scalia actually smoked a pipe during his hearing, if you can imagine, like Sherlock Holmes. But Bork was going through a withdrawal of nicotine during his hearing, so he was extremely agitated, more so than usual. So we can blame lack of tobacco for part of his performance. But during Bork's hearing, he was seized upon by men like Ted Kennedy and Joe Biden. And for the first time ever, the Senate specifically said, we will reject a justice based on ideology. Presidents had appointed based on ideology for many years. Franklin Roosevelt threatened to pack the New Deal. Pack the Supreme Court with justices who would uphold the New Deal. That was his express purpose. So the idea of picking ideological judges goes all the way back. But for the first time, the Senate, Ted Kennedy and Joe Biden, said, we will reject the nominee because he's too conservative. That was novel. Was Bork any more conservative than Scalia? Maybe, maybe not. I don't know. But they were in the same ballpark. Scalia got through 97-0, as you often like to remind people. 97-0. So after Bork was borked, as the verb became, President Reagan announced that he would nominate this man, a guy named Doug Ginsburg, who no one remembers. He was my professor at George Mason. He was a great man as well. Ginsburg was never actually formally nominated. The reason why is that less than a week after it was announced, National Public Radio released a study or a story suggesting that Doug Ginsburg, when he was a professor at Harvard, smoked pot with some students. Right, today smoking pot's awesome, right? It's legal in states, and the president admits it. I never inhaled, whatever it is, right? But back then, with Bill Bennett, Nancy Reagan just say no, this was not an option. So Ginsburg went up in smoke, quite literally. His budding nomination went nowhere. So within a week, Reagan had to turn not to Plan B, but to Plan F by quickly nominating Anthony Kennedy to the Supreme Court. And you can see Attorney General Meese in the background smiling. You'll probably look back at that photo and regret that one. We should take that one back. Kennedy was picked because they were desperate. They'd already gotten shut down twice, and they needed someone to be on the court. They picked him literally within 1 week of Ginsburg withdrawal. They needed someone quickly. So for all of you saying, oh, the Senate Democrats confirmed Anthony Kennedy in election year. Okay, let's talk about dates for a minute, right? Lewis Powell resigned in June of 1987. Robert Bork was voted down in October of 87. Kennedy was nominated in November of 87 and confirmed in February of 88. Kennedy was confirmed in February of 88 only after a 220-day filibuster and blocking of Reagan's other nominees. So I'm sorry, that does not create a precedent for confirming a justice in election year. It's simply incongruent. But Reagan picked Kennedy because he was a moderate. He had the endorsement of, among others, Lawrence Tribe. Tribe, who did everything in his power to stop Bork. Indeed, Tribe likely ruined his own chances at the Supreme Court because everyone hated him after that in the Senate. But Tribe endorsed him, and Joe Biden and Ted Kennedy, no fools, Kennedy sailed through. I think his vote was near unanimous or close to it. And here is Kennedy getting sworn in by the chief. And 30 years later, Justice Kennedy's still there, and I'll let his decisions speak for themselves of what he's accomplished since. But this is what happens when Republicans don't fight for their appointees. The next major opportunity arose when William Brennan, New Jersey's finest, resigned from the Supreme Court. This time, Biden and Kennedy realized that this could potentially shift the court, because this wasn't Justice Powell's seat. Powell is a conservative moderate. Brennan was the liberal line with his 5 fingers, do whatever he wanted. So President George H.W. Bush and his chief of staff, John Sununu, were confronted with the situation of who to appoint. H.W., God bless him, did not want to fight. He did not want a massive political fight. He had other things to worry about. The Gulf War, taxes, whatever else was on the mind, things we don't even care about today. So he said, let's put a stealth nominee, someone who can just sail through, won't raise any red flags, and be a solid conservative. So John Sununu and Walter Rudman of New Hampshire picked this man, David Hackett Souter. Souter was a Supreme Court justice on the New Hampshire Supreme Court for a number of years, and he was on the First Circuit Court of Appeals for about 5 minutes. I'm only slightly exaggerating. He was only there for barely a year. And here's a picture of Sununu, Rudman, and C. Boyden Gray smiling as H.W. announces David Souter. And here's Souter. And, that look on Souter's face is actually very fitting. Like, me? Because who was David Souter? We had no idea who this guy was. We had no idea. He had not done anything of significance, and that's what H.W. liked about him. He liked the fact he had no record. Biden's like, wait a minute, this could be worse. So they put up some, smoke screens against Souter, but they let him through. As Senator Ted Cruz has reminded people, and by the way, I'm supporting Senator Cruz, he could have also picked another judge by the name of Edith Jones, who was in consideration. And Bush chose Souter over Edith Jones. What a different world we would be in if Edith Jones was in the Supreme Court instead of David Souter, and Robert Bork was in the Supreme Court instead of Anthony Kennedy. Casey would have never happened. Roe would be gone. There would be no Lawrence v. Texas. Name your case, it's gone. The next opportunity arose was when Justice Thurgood Marshall, the great civil rights champion, died. And H.W. was given a choice, a momentous occasion. Here, H.W. knew, by the way, H.W. is Bush 41. I'm in Texas, I can say that. H.W. knew that there would be a serious political fight. And I don't think H.W. wanted the fight. He thought he would be able to pass on and appoint this man, Clarence Thomas. I don't think President Bush understood the fight that would ensue by appointing Clarence Thomas to the United States Supreme Court. I don't think he had any idea what was going to happen. He was blindsided because now Biden and Kennedy realized that this man was a conservative. There's no doubt about that. Talk to anyone he knows. Look at his writings. Look at his readings. Look at what he said. Look at his speeches. He was a conservative. And, Biden and Thomas are all smiles here. It would not be smiles for very long. This is Justice Thomas with his wife, Virginia, sitting behind him. Because soon enough, the hearings blew up. Justice, God forbid, Joseph Biden. By the way, someone actually asked Vice President Biden, would you consider serving the Supreme Court? And he said, no, I would not consider it, but thank you. Joseph Biden, Senator Biden, attacked Thomas for holding views that were conservative, for holding views that were libertarian. He attacked him because he liked Richard Epstein's writings. He said anyone who would ever rely on Richard Epstein's book takings is not fit for the Supreme Court. I will say that's one of the best books of legal academia ever. So I guess I'm not suited. So Biden went after him. But then the next scandal broke. So Anita Hill, who worked for Justice Thomas at the EEOC, made allegations that he sexually harassed her. Indeed, there's actually a movie on HBO coming out now starring Kerry Washington, the actress from Scandal. I think it's called Confirmation. I think that's what it's called. The timing of this miniseries is propitious, I suppose. And Thomas would go on to describe it, paraphrasing, but he said it's a modern-day lynching or a 20th century lynching, the way he described that they went after him. And I'll repeat a comment I read elsewhere. If we were appalled at the sorts of things that people said about Justice Scalia upon his passing, I cringe to think of what will be said for Justice Thomas. That will be many, many decades away. I want him to be in the court to be 120. But the sort of vitriol we saw in the last week, I think will be even worse for Justice Thomas. But he was confirmed, barely, by a couple of votes. It was one of the closest votes in Senate history. And that's actually Justice Byron White, who was the Chief Justice, was out. I forgot exactly what he was out, and he was sworn in. I'm going to skip the 90s because they don't matter, right? Clinton appointed Ginsburg and Breyer, and they did what they did. Right there. I mean, again, it's unfair to say this, but the difference between a moderate and a liberal is, smidgens. But the difference between David Souter and Clarence Thomas is worlds. So we fast forward now to the modern Supreme Court. By the way, if you notice, Justice Thomas is not staying next to Senator Biden. I think that might have been a little too close to home. Okay. So now let's focus to a man who lived in this town for many years, George W. Bush. When Justice O'Connor announced her resignation, George Bush had one opportunity. Shortly thereafter, Chief Justice William Rehnquist died. It was unexpected. It was an unexpected death. Now, Bush had two nominations to make at once. His first nomination, which I'll get back to in a few minutes, was for John Roberts, who was a D.C. Circuit judge. Initially, Bush wanted to put Roberts as an associate justice, but then when Rehnquist died, he said, okay, I want to make Roberts the chief. To fill Justice O'Connor's seat, President Bush initially nominated Harriet Miers, who was his White House attorney and was a longtime petitioner in Dallas. So one of the problems with Justice Harriet Miers, who was never confirmed, was that, again, we did not know anything about her. And at the time, this cartoon is actually close to home. So if you read Jan Crawford's book, Supreme Conflict, this is actually disturbing. The person vetting Harriet Miers, the White House lawyer vetting Harriet Miers, worked underneath Harriet Miers. You want to talk about a breakdown in process, that's one. The second big red flag is that Senators Schumer and Reid endorsed Harriet Miers. They said, yeah, sure, we'll confirm or whatever, right? That was the next red flag. But the final red flag was when she started meeting with members of Congress. And the senators did not like her very much. And they said, this person is not qualified. Now, she's a wonderful human being, a good lawyer, but they said, she's not meant for the Supreme Court. Okay? So we have this sort of political fight. Okay, so what does this mean going forward? And now this part is actually really relevant. I'm updating my presentation as I speak. This is my first new one since the passing. So traditionally, the Senate had what's called a filibuster. There was a 60-vote limit in order to advance any judicial nominee. You had a 60-vote limit. You had to get to 60. This limit was used by Senate Democrats throughout the Bush administration to block men like Miguel Estrada and Charles Pickering and others from the courts of appeals. I think it was Schumer or Reid who said we can't let Miguel Estrada because he might be a good pick for the Supreme Court, that they denied an immigrant a job on a federal court because he may make a good justice. Embarrassing. It's embarrassing. But fast forward to the Obama presidency. As soon as Republican senators started to filibuster judges, the exact same thing the Democrat judges did, Harry Reid triggered what's called the nuclear option. Nuclear, right? The nuclear option. What's the nuclear option? You no longer need 60 votes to appoint a circuit judge, right? You can now get a circuit judge through with a 50-vote bare majority, okay? Why is this relevant? Well, Senator Reid said, well, we will not nuke the Supreme Court nomination, right? We will only nuke circuit judge nominations. So as it stands now, you still need 60 votes for a Supreme Court nomination, right? But we should not kid ourselves. We should not kid ourselves, because the next president who wants to appoint a justice, the Senate will stop at nothing to eliminate that requirement. Senate Democrats will do it in a heartbeat. Now, I want to tell you guys a doomsday scenario. This is going to scare the crap out of you, if I can use the phrase. Under the Constitution, the Senate meets on January 3rd. Under the Constitution, the president is inaugurated on January 20th. There's a 17-day window between the Senate meeting and the president meeting. Okay, follow me here. If a Republican wins the White House and the Democrats take the Senate, there will be a 17-day period where Barack Obama is president and Chuck Schumer is the Senate Majority Leader. There is nothing stopping them from appointing and confirming a justice in 17 days. I'm not joking, my friends. There is nothing the Constitution says between January 3rd, when the Senate Majority Leader steps in, and January 20th, when Barack Obama is still in office, to fit a Supreme Court nomination to 17 days. That is the serious thermonuclear option. I'm not joking. This is legitimate. I mean, I've already done the math. So all they have to do is effectively say, we will not put this through committee. We'll change the rules by bare majority vote, And if it's a tie, even if it's 50-50, Biden can break the tie, and they get whoever they want in the last 2 weeks of the thing. And by the way, this is after the election, so elections no longer have consequences. That's the true nuclear option. But the less likely nuclear option is the next Senate will simply go. Has been meeting now. I specifically have been discussing for months the possibility that we may have an empty seat for an extended period of time. I swear, I'm updating this as I'm speaking. Let's got to figure it out. We have an empty seat for some time. Justice Scalia's seat, I don't think will be filled before January. It may. I don't think it will. And we'll probably have a confirmation hearing at some point in February or March, meaning the justice can take the bench in April, which is probably too late for most of the cases. They can always re-argue stuff. But because of the nature of this political controversy, we are going to have a situation where seats may stay empty. This actually happens in state courts all the time, where, for example, in New Jersey, you had Republican Governor Christie, you had a Democratic legislature. Seats have stayed empty for a while. This is not salutary, but I think is a consequence of the state of our political system and how people don't trust each other on either side. I don't have a solution for this, but I'm making an observation of how things function. The second major lesson that I'd like to discuss is that paper trails are an asset and not a qualification. I'm sorry, an asset, not a disqualification. Sorry, I said that. Why? We don't want judges who are blank slates, right? We don't want judges who are, ships drifting in the sea without sails, where they are. We don't want people like John Roberts, for example, who have shown a propensity for being swayed by the Washington class. We don't want self-judges who are appointed because they think they'll sail through the confirmation hearings. This was actually a cartoon when John Roberts was up. It says, not much of a record for us to shoot at, but look at the size of that right wing. Well, right wing is a little bit smaller than we thought.
Yeah.
Same for Elena Kagan, who I think is I've become an Elena Kagan fan. I mean, she is a brilliant writer. Put aside her jurisprudence, she can write. I mean, right now, I think her and the chief are the best writers in the court. Now that Scalia's gone, it's a two-way tie. But it's easily a two-way tie. But so too with Kagan. As an academic, she wrote like 3 law review articles in her entire career. I wrote more this year. Okay, I'm not bragging, but she did not like writing stuff. That wasn't her thing. And she was never actually outspoken anything. So she was stealth. But again, Barack Obama did not need to worry about her, as they say. So one other notion I want to discuss, and you may have heard of this, is something called the Little Supremes. Anyone ever hear of the Little Supremes? These are people who are so intent on becoming justices that they shift their entire lives to make their confirmation hearings easy. They never take any public statements. They never write anything controversial. They are always doing stuff. For example, if you ask John Roberts' friends, what do you think of affirmative action? They have no idea. He never talked about it. John Roberts denied being a member of the Federalist Society, even though apparently he paid dues. His firm paid it, so they say, and attended all these meetings. We don't want people like this. Indeed, this is talking about Little Supremes. Elena Kagan's high school year at Hunter High School, she was in a robe. And speaking of Felix Frankfurter, she had a Frankfurter quote in her high school yearbook. I don't know who the hell Felix Frankfurter was until I got to law school, but she said, "Government is an art. Government is itself an art, one of the subtlest arts." And if you want to laugh at this, is Sam Alito's Princeton yearbook, and it's hard to read, but it says, "Sam intends to go to law school and eventually to warm a seat on the Supreme Court." And indeed he did. So now I want to talk a little bit about a person who people in this room may not agree with, but I think that's something wise to say. So this is Pamela Karlan. She is a law professor at Stanford. She worked in the Obama administration, and she's a self-professed liberal. She is extremely liberal in everything you can imagine. But she was so liberal that Barack Obama did not nominate her to the Court of Appeals. She should have been a Ninth Circuit nominee easily. But she wasn't because Obama didn't want the fight. And someone asked her, would you like to be in the Supreme Court? And she said, let me read you. She said, Would I like to be on the Supreme Court? You bet I would. But not enough to have trimmed my sails for half a lifetime. In a lawyer, courage is a muscle. You develop courage by exercising it. Sitting on the fence is not practice for standing up. Imagine what it takes to live your whole professional and personal life as a justice in waiting. Those are very profound words. Courage is a muscle, and we should look for people who have this sort of courage that's backbone, strong, right? This town, Washington, D.C., has a good way of picking off people who don't have that backbone, right? National Public Radio and the New York Times and the Wall Street Journal, they have a way of affecting people. Indeed, after the Obamacare decision was decided, Glenn Beck had a T-shirt for sale with a picture of the Chief Justice and the word coward underneath it. And to that point, if you notice, Chief Justice Roberts always speaks of John Marshall. He wants to be like the great John Marshall. Let me tell you something. John Marshall is not a very good justice. Marbury was wrong, okay? He should have recused, and he screwed up the Judiciary Act of 1789. The entire case was wrong, right? Everything about it was wrong. Yet we revere him because he had this twistification of the law with this and that. Not in my classroom. My students know better than to like John Marshall. We need less John Marshall and more James Madison, right? We need less John Marshall and more people focusing. We need people talking about the Constitution and not the Supreme Court. Okay, the final 3 lessons go a little bit quicker. So I have several Institute for Justice people in the room, so I can let you do this. But we need to reject cliche calls for judicial restraint, right? This is something which we're all taught in law school, that the legislature, that the courts are, activists. We can't have restraint. The problem here is that the phrasing, as Clark Neely has written an entire book about, doesn't do much work, right? And to give you an example that's very easy, think about Obamacare, right? The Affordable Care Act challenge. I like this one also. We have 2 George W. Bush nominees. We have Sam Alito and we have John Roberts, right? One of them voted to uphold Obamacare, the other voted to invalidate it. Which one was activist? Which one was restraint? Well, it depends how you look at it, right? Sam Alito said the mandate is not within Congress's powers under the Commerce Clause, therefore it's unconstitutional, strike it down. John Roberts also said the mandate is not within Congress's powers under the Commerce Clause, therefore it's unconstitutional. However, John Roberts took one step forward and said, but you know what? This looks a lot like a tax, so I'll pretend it's a tax and uphold it. To the extent the words activist and restraint have any meaning, Roberts' opinion was quite activist. He rewrote the Affordable Care Act to insert a tax that Congress deliberately did not put in. When Congress was debating the ACA, they said, we cannot call this a tax because that will be political suicide. John Roberts said, you know what, but like John Marshall before me, I have a duty to uphold the statute. There's nothing restrained about that. Judges here are not calling balls and strikes or throwing curveballs. And we need to make sure that this meme of just simply being restrained in all situations is not adhered to. And if you ever get a chance to read this book by Clark called Terms of Engagement, Here He Is with a Pipe, I encourage you to do so. And I'm sure Clark has spoken here before. If he hasn't, he will. He's coming to town real soon. The 4th lesson, and this is a little bit more meta, we need to focus on the Constitution and not specific issues, right? There are lots of big issues that come before the court that are unpredictable. Obamacare, as I cover in my first book, Guantanamo, Bush v. Gore. There are all these cases that kind of nowhere. And it's very hard to predict a judge, right? Sir Luserman, right? It's very hard to predict. So I think the idea of these litmus tests need to go away. Now, on the Democratic side, remarkably, Bernie Sanders and Hillary Clinton have called for a Citizens United litmus test. Any lawyer who's taken professional responsibility knows how unethical that is. Once a judge says, here's how I will vote in a case, they have to recuse. Hillary's a lawyer. She should really know better. But Sanders, whatever. Do you know Bernie Sanders never earned a paycheck till he was 40? Did you know that? His first paycheck, his first steady paycheck he got was as mayor. So he knows a thing or two. So that's my friend Grace, and she's actually my co-clerk from Judge Boggs, and she's feeling the burn. Not I singled her out. You're welcome. But the issue is these litmus tests are idiotic because once a judge tells you how they'll vote, they have to recuse from that case. This is idiocy. But more importantly, knowing how a judge votes on, say, a case about abortion or gay marriage, whatever, doesn't tell you much else. One of the reasons why John Roberts was selected was because he was solid in the war on terror. In fact, inside baseball, he issued a case on Guantanamo, I think, the day before he was nominated. It was a very pro-executive power decision. I'll give you another example. The rumors are Michael McConnell, a man of great integrity, was a judge in the 10th Circuit, was not picked for the Supreme Court. Why? Because the Bush White House thought he'd be wishy-washy in Guantanamo. What a shame. What a shame. So stop with these litmus tests and focus on the Constitution. The final one, this is actually something Randy Barnett is a big fan of, is the confirmation hearings have become a joke. If you ask a justice, what do you think about, the Second Amendment? They'll say, well, District of Columbia v. Heller, yada, yada, yada. Let me tell you something. Sonia Sotomayor was asked, what do you think of the Second Amendment? And know what she said? Heller was, quote, settled law. Heller was settled law. Not even a year later, in the case of McDonald v. City of Chicago, she basically voted to overturn Heller. Settled law means nothing because you're on a justice of the court and stare decisis doesn't have any meaning. Justice Alito famously said, if you were in Dallas, Alito said, stare decisis means you pull the case when you want to. Paraphrasing here. But what if you ask the justice, tell us about the original meaning of the Second Amendment? Whoa, right? Tell us about the original meaning of the Commerce Clause. They'll have no idea. So perhaps one way to make these hearings actually more meaningful is instead of asking about cases, asking about clauses of the Constitution. Anyone can talk about cases. You can be prepped on that. But understanding the history of the Constitution is a lot harder. And I think some of the justices may actually falter during their hearing on this. So I'm going to stop here. I spoke longer than usual because I had my introduction with Justice Scalia. But I welcome your questions. And I hope this is a discussion that we in the Federal Society and outside can keep going. Because in the upcoming election, there's no more issue of importance than the Supreme Court. And if nothing else, we know with much certainty that the very first act the next president will do will be making a nomination to the Supreme Court. The very first act. And I'll stop here for questions. Thank you all so much.
I had a friend who watches West Wing.
Oh, yeah. I know the episode.
And they got the older justice to resign, appointed two, one liberal, one conservative. But be that as may, there's some effort. The press is saying that Obama's trying to find something that would be acceptable. What's your top five?
I'm not giving names.
Okay.
No, and I have reasons for doing so. But the short answer is, and I mentioned this before, how do I put this? Obama is not stupid. Right? You can say a lot of things, he's not stupid. If he appoints someone who he says is a moderate, it's likely that the person's paper trail suggests, or lack of paper trail suggests he's a moderate. But for the most part, these people know each other, right? I have friends in this room who, I know stuff about them that will be written down. And I'm fairly certain that the person the president picks in his heart of hearts will be someone who will support his agenda, support his legacy. And there's nothing wrong with that. Let me make this point really clear. The president has a unilateral power of picking whomever he wants for whatever reason he chooses. There's nothing wrong with that. It's part of the constitutional prerogative. But I think this myth of the moderate is misleading for a lot of parts, because even if the president nominates someone who's in the middle, as that chart I showed you demonstrates, they shift left. So it'll be up to the Senate Republicans to do whatever they're going to do. I have zero say in that, but I'm very skeptical about the idea that a moderate justice is much better than taking a risk at winning the election, getting one of your own. Yes, sir.
Can President Obama make a recess appointment to the Supreme Court?
It's funny you mention that. So on Saturday, I was in a very dark place, but within 30 minutes or an hour after I realized he died, I was like, holy crap, they're in recess. It occurred to me immediately. And I had this chilling moment as I was frantically emailing people on the Hill saying, you need to go into session immediately. I did. Because Justice Scalia's opinion in Noel Canning, the 2014 case, lambasted Breyer. Why? Breyer said a recess of less than 3 days is presumptively too short. Right? It's too short, unconstitutional. What about between 3 and 10 days? Breyer didn't quite say. He said, well, it's probably not good, but if there's some sort of national catastrophe, then the president can fill it. And Scalia's dissent, these chilling words from beyond the grave speaking to me, I had chills. Scalia's dissent said, who are we to know whether the next president will deem a catastrophe or not? Right? What the next president says a vacancy in the Supreme Court is an emergency. We got to fill it. So I was, for 2 hours, freaking the heck out that Obama was going to reappoint whoever it was to the court. I was legitimately concerned. Go give John Paul Stevens another go at it, right? Whatever. Make it diplomatic. Give it Sandra Day O'Connor. But I was freaking out. But I was assured, but 2 hours later, that the Senate was aware of this. They were in touch with the White House, and it did not happen. So I don't think the president will do that at this point. Yes, ma'am.
After Reagan had his regrets about Sandra Day O'Connor.
When did he ever regret Sandra O'Connor? I don't think he ever did.
I think that he did. He did say that.
I don't think he did.
Well,
And Jerry Ford never regretted John Paul Stevens either.
she did vote on the other side. I mean, a lot of the time, and that was regretful for people like me, who's a conservative. And so you have that situation. You have David Souter. You have John Roberts. And in your talk, you talk about there should be no litmus test.
Mm-hmm.
I mean, I would say you need a litmus test more than anything, especially now when there's possibly 4 seats. I mean, can you imagine our country if we had 4 more?
And we'll make America great again.
But I mean, so,
There it
I don't
is.
know, maybe I just didn't understand your argument as to why.
Well, the problem with the litmus test is one of judicial ethics, and we have a couple of judges in the room. But generally speaking, when you, as a judge, come out and say, "Here's how I will vote on a specific issue," you are now recused from that issue. So practically speaking, it's foolish because you're basically taking your judges off the bench.
I see what you're saying. I'm bet from the other side, from the president's perspective, like I'm not going to pick this person because they're cloudy on this issue.
Well, that's fine, right? And that's why I think paper trails matter. Instead of asking the person outright, "How will you vote on issue X?" which I don't think you can do realistically, you say, "Okay, he's had a case involving, say, federalism as a circuit court, or is it a case involving the Second Amendment as a circuit judge, or he's had a case involving economic liberty as a Texas Supreme Court justice." Don wasn't even paying attention to that. Yeah. We can thread it later, Don. So you look to a person's track record to figure things out. Yes.
Well, just sticking with that though, Kagan, when she was Solicitor General, she tried to put firewalls between her and
Yeah.
certain issues.
Oh, she did?
But I mean, it was a questionable effect, and she did not recuse herself from a number of issues that clearly she had to have known about as Solicitor General. The point what that lady's bringing across is what you said is a practical matter, but when you're on the Supreme Court, all bets are off. If you choose not to recuse yourself, there is no mechanism to force you to recuse yourself, and you do not have to give your rationale one way or the other. And I would use Kagan as an example. If you have some kind of fig leaf, then you just will not say anything, you will not do anything, and you'll just vote on the case, whether you gave a litmus test answer or not. So I think that's why Hillary and Bernie feel quite confident of doing litmus tests, because a justice appointee willing to submit to those is willing not to recuse themselves later.
Oh,
That's my concern.
that's a fair point. So first on Kagan, actually, I wrote about this in my first book. She did not need to recuse on the Obamacare case. The reason why is she did everything in her power not to be involved with it. I go through this. There are a series of emails where her deputy, a guy named Neil Katyal, contacts her. "Hey, Elena, there's this big meeting at the White House on Obamacare. Do you want to come?" You think the answer is, yeah, let's go, right? What's her answer? What's your phone number? What's your phone number? The hell's into that? After that, she was walled off on every single decision. And this wasn't like a Chinese wall. This was a literal, she was not contacted. In fact, when she was nominated, there's FOIA. There was an email that she sent to the PR person at DOJ yelling at her saying, "I can't believe you talked to the press about this issue without me. You need to check with me." She was so diligent about not having any contacts because she knew she'd be appointed. And she can do the math. It'll be up at the court when she's out there. So,
Yeah,
but another point about Kagan, for example.
You do the phone, you do paste.
So another point about Kagan, though, not like it matters. She was asked during her hearing whether there's a federal constitutional right to same-sex marriage, and her answer was no. She was asked point blank, "Is there a federal constitutional right to gay marriage?" And she said, "No." So yeah.
I thought your other, excuse me, in response to the question, I thought your other argument against litmus test was more persuasive, and that is,
Good. I'm
if
glad.
someone's gonna be on the court for 30 years, worrying about whether Justice Roberts, how he feels about Guantanamo Bay,
Yes.
is not a reason to appoint someone,
Absolutely.
because there's a panoply of issues that
Right.
can come up.
So that's the other fair point. Not to repeat it, but you don't know what the next issue du jour will be. We don't know. I mean, if I told you in September 10th of 2001 that the Supreme Court would soon have to decide whether President Obama can keep a bunch of jihadists in Guantanamo Bay without a hearing, you said you're insane. That's how the world goes, right? If in 2008 you said the court will decide whether this law that makes everyone buy health insurance is constitutional. Like, what are you crazy? What are you talking about? So focusing on issues and track records and what people think about the law. I mean, the reason why Scalia was a giant was an academic, but he was a thinker. He could think. He could develop rules that other people listened to. He was not trying to decide one case at a time. He had to develop a theory of the law. John Roberts told us he had no theory of the law. It was whatever it was, case by case. Okay, we have a couple more minutes. Another question? Yes.
How does the fact that HW managed to get Clarence Thomas at the court kind of factor into everything that you're saying? Because I mean, I get the
He barely snuck through. He barely snuck through. He only had a couple handful of votes. And back then, I mean, to make the point more broadly, there was still such a thing as a moderate Democrat, right? There were still some Democrats who would jump over and vote. We're at the stage today where the American South has not a single Democratic senator, not a one, right? There are very few people you could actually call moderate Republican or moderate Democrat. We don't. So the electorates now, it's going to be a straight party line vote. I'll give you an example. Last year, or 2 years ago, the Senate voted to amend the First Amendment. 47 Democrats, every one of them voted to basically repeal the Second Amendment in part. Party line vote. Insanity. Okay? They'll vote as a block, right? Republicans don't have that same sort of compulsion, but they'll vote. Maybe someone has a question for us. I'll try.
I just wanted to respond to the.
But let's try. Someone hasn't spoken yet. Yes? Good.
Professor, I'm going to test your position of not naming any names. Next year, would a President Rubio ever consider
Jerry Swift. No, I'm sorry.
ever consider appointing Senator Ted Cruz? Would a Senator Cruz consider accepting a nomination from President Rubio? And then would the Senate ever actually confirm Ted Cruz's appointment?
So again, I'm advising Senator Cruz informally at least. And let me answer your question this way: Hugo Black. Okay, why did President Roosevelt appoint Hugo Black in the Supreme Court? He wanted to get him out of the Senate. Can you imagine? Roosevelt's like, this guy's a thorn in my side. Let me stick him on the Supreme Court. Because Black was a rabble rouser, he's a flame rouser too, but he was a rabble rouser, and they put him on the court. Would a president want to appoint a senator from a safe seat in Texas? I mean, it could be an interesting idea. I think a senator would bring in most cases, a senator knows how to build coalitions and build consensuses. But with respect to to our junior senator, that may not. O'Connor, for example, has often said she was a legislator, and that was her strength. She'd build consensus. So I don't know that. I think Senator Cruz would make a great justice, but I don't know that that's why President would appoint her to the court. But the bigger question is, would you appoint a politician to the court, someone who wasn't a circuit judge? Virtually every single one Kagan accepted was a circuit judge, right? At some point and Kagan was an SG, so that's basically the same thing. But by the way, when Lagan Kagan was nominated to the court, she basically had no experience as a judge. It's interesting to think about it. She was an SG for like 8 months, and then she walled stuff off from the most important cases. So I'm not trying to dodge your question, but I mean, I think a politician can make for an interesting choice.
I'd like to hear Patrick's comment since he clerked for Justice Thomas.
Yeah, no, I didn't mean to cut you off, but I want everyone to get a chance. Anyone else have a question before? Because we're running out of time in a minute. Anyone else? Okay, go ahead, please.
Well, I was just gonna say, actually, Justice Thomas could have won confirmation with a larger There could have been a larger measure of votes for him. There was a lot of horse trading done behind the scenes. And there was more that could have been done to pick off a few more Democrats to vote yes. And basically, Bush 41 decided that was enough, that he was getting him over the goal line and didn't need to cushion the amount that he was getting him over, but he could have. So it actually could have been a bigger margin than it was, which is why I'm actually against holding hearings now, because I have a feeling the exact same thing would happen, but with Republicans. There's a number of moderate Republicans, you can think of a few, perhaps one from Maine, where it'd be very easy to pick their votes off, because after you have hearings, you almost certainly have to have a vote. And that's where the horse trading starts, and you pick off a few moderate Republicans and bang, you got your.
Or you vote it down in committee. You don't let go of the floor. You vote. You have a hearing. You vote it down in committee. You don't have to let go of the floor. Vote it down. That's a possibility.
It's a possibility.
And the SGC members maybe a little bit less mushy. But actually, this morning, Senator Grassley and Senator McConnell had a piece in the Washington Post saying it was very artfully worded. It said we will not confirm a nominee this year. It said nothing but hearings. It said we will not confirm a nominee. I think we're out of time. Any other questions? Okay. Thank you all so much. Appreciate it.